Hello guys, welcome back to another video. In this video I'm going to cover up the chapter 6, law of partnership. Let's get into it. What is the law of partnership? So according to the applicable law, this is derived from English law. It's the concept into Sri Lanka. So it has been mentioned in the section 3 of Civil Law Ordinance number 5 of 1852. It says that in all questions or issues which may hereafter arise or which may have to be decided in Sri Lanka with respect to the law of partnership to be administered shall be the same would be administered in England in the like case. So unless if there are any case other provision or shall be made any enactment now in force in Sri Lanka hereafter to be enacted. So yes, quite interesting. So there are two acts, so which is Partnership Ordinance and the Partnership Act. So in the Partnership Act is from the United Kingdom. Sri Lankan law is a Partnership Ordinance number 21 of 1866. Quite interesting. This came during the British colonial system. So it is very similar to the UK law. So if there's any legal dispute and issues, we look at the legal law in respective of the United Kingdom, and if there are Sri Lankan laws that are derived from the cases, we'll be looking to that as well. So what is a partnership? So section 1 of Partnership Act says that the relation which subsists between persons carrying on business in common with the view of profit in relation to the connection that exists between parties. So partnership also can be a firm, so such as law firms, architectural firms, chartered accountant firms, things like that. So partnership can be built upon within two friends, within families, husband and wife, and so on. A classic example, law firm is Neelakandan and Neelakandan, so which is the husband and wife started the law firm, which is located in Vallavattahin somehow, I believe. So it's a classic example. So partnership businesses is between two parties that they start a business with. So what are the requirements? So there should be a valid contract between parties. The partnership must be related to a business, not just common domestic things. And according to section 45, state that what is a business? It can be a trade, occupation, or a profession, things like that. So a business must be carried out probably in common. So what is in common? It has been mentioned, and examples of a common also has been mentioned. And the partnership the business must be operated with the view of making profit. So that is also one key highlight, because without making a profit, they both ended up contributing their own money, their own capital into some sort of a thing. So there's a case, a classic example of partnership of making profit. So let's get into it. Smith versus Anderson. So first case, shares in a number of telegraph company in the nominal amount of 400,000 were purchased by subscription and vested in trustees. Each subscriber received for every 90 pounds subscribed in subscriber certificate for the nominal amount of 100 pounds and a deferred coupon of 4,200 part of the funds. The number of certificates being 4,200. The trust of funds were declared by a deed between trustees and a covenantee on behalf of the certificate holder. Yes, so members of a society are formed to purchase investments for the common benefit of the members. Example, fixed trust, which are not partners. says as test to determine whether partnership exists. So there are tests whether. So first of all, when there's a court case going on, first they will look at apply these tests such as joint tenancy, if there's a sharing of gross, and generally what sort of a profit that they have shared equally. So the courts will look into whether there's an actual partnership existed where there's a business registration, and what sort of steps that are followed in order to they have established some sort of a partnership. I know. So the receipt of the person, the debt in amount to liquidate to the business. So whether there are contracts has been made, so whether the other party has, if there's a death of another party, so which will carry on to their widow or child, and there's advancement of money, provided that the contract is in written on behalf of parties. So whether there's an annuity, and where proportion of profits in the business consideration, and sale by goodwill with a liable of a partnership or in the business and such. Yeah, so what are the general characteristics? So characteristics are should be a contract with the express or implied. Partnership must have the business in common. They both must have business in ideas. So such as when they have a plastic business, they should have things in common. When they are doing a profession, such as a chartered accountant firm, architectural firm, or law firm, they should have in common what are the things. So partnership formed with the intention of making profit, of course. There's no legal existence for individual members. Partner cannot transfer his or property share to a third party. Yes. Without consent of all other partners. Yes, exactly. So a partnership is an agent of the partnership, therefore A can bind by the partnership. So it's like some sort of a direct boss. So it can be between two parties, it can be between quite a few members. So they are the one who comes and sit down on table and decide what is the fate of the company is going to be. So it can be in both wise. So moving on, so applicability prevention of fraud ordinance. So prevention of fraud ordinance 1840. Section 18 states that the agreement of deed creating the partnership must be in writing and signed by all partners if the capital established partner exceeds 1,000 rupees. Exactly. So this kind of partnership has to be written by a deed and has to be submitted through the which called registration of business. So if this condition is not complied, so what are the agreements? So Abe Gunasekara, ET versus Mendes. This is a Sri Lankan case. And there's another one, Rajasegaram versus Rajaratnam, Privy Council appeal, 1960s. And so this course cases is going on, Pate versus Pate in Privy Council. So please go ahead and read this. So another call is Sinyo versus Punchihami, Aralias versus Francis. So these things cases are Sri Lankan cases. So please read and understand what is it. Idros versus Sheriff, Proviso. If the state statute of fraud or is a weapon or defense, it's not a weapon of offense. It's a person who sued on the basis of the partnership entitled or lead oral evidence partnership. So Hasi versus Horn Payne. And that's another Balasubramanian versus Vallaipa. So section 18 only prevents partnership of being established in the absence of written agreement as the basis of suit, will not prevent proof of partnership by evidence or oral before court. So Commissioner of Income Tax versus Aludin, 1953. And yep, finally we're coming to registration of partnerships. So it is not compulsory to register a partnership, but under some circumstances, depends on your the work that you do, depends on the profession that you do, it can be compulsory. So the compulsory comes within the Business Name Act number 7 of 1987. So the section 2 says that every firm having a place in business in Sri Lanka and carrying a business under a business name which does not consist of true full names of all partners who are individual and corporate names of all partners who are corporations shall register the name under which the partnership business is carried upon. So section 5 state that if you want to register business, you must have this criteria such as the name of the business, the nature, the principal place of the business, the address, the branch offices if you have any, so which is the head office located in somewhere else, and what are the branches has been located in any other places around the country. So the name, nationality, residential address, the occupation of each partners, so that is common, and the date of commencement of the business, so that means when do you started the business. So these things criteria has to be fulfilled in order to register a business. So it says as registrar of business names within 30 days of such change. So if there's an any that means so if you make a name for your business within 30 days, they will give that whether this business name has been approved or not, because they will have to search on other businesses whether this kind of business name is exist. But if there is an existence of business, there should be you must change the name of the business and you have to come up with another one. So that's why most of the business, when they're starting, they must have more than 10 names of the businesses. So each and everything they will correct it, and they will give you some sort of a report within 30 days for registrars of business, registrar of companies department. So they will tick it, mark it, what are the names that you can have for your company, and what are the names that you cannot have in regards of representing your company. So yeah. So limitations of number of partners. So according to the Companies Act number 7 2007, section 519.1, so must have up to 20. So that is the thing. So exemption to the general rule says that give instances where a partnership can Sri Lanka have more than 20 members. These instances are as follows. So if you want to have more than 20 members, so you must show these we must fulfill these criteria. So if you are practicing attorney at laws and all the partners are attorney at laws, so that means if you are a law firm, so you must have more than many lawyers as much as they can, because you have to cover up so many law area. So if it's a law firm, there's an exceptions. You can have more than 20 members. And if it's also an account firm, chartered accountant firm, because you can have, because since if they are operating many companies, you must have as much as accountants as possible, because the more the better, the more the workload is much more lower. And yeah, stock exchange, when they do license stock exchanges, you must have many partners in the workplace in order to because in order to fulfill their criteria. When the stock market is crashing, when it's uprising, they must have communication between two parties. And if the partnership is formed for prescribed purpose and all partners are as prescribed, so this is an actual thing that you have to argue within the company. So it depends on your business, what is meaning of prescribed. So what sort of prescribed business that you are going to have. So yeah, the partnership property. The Partnership Property Act 1890 in section 21 state that all properties of right interest or the originally brought into partnership stocks are acquired, whether the purchase or otherwise, on account of the firm purpose, so-called partnership properties, and must held applied between exclusively purpose of the partnership according to with the partnership agreement. So these are the cases if these things are violated. So those properties, PP, I would say, can be divided two categories. Properties that are bought in originally, properties are acquired subsequently by the partnership. So what are the properties that is included? It can be a land, building, or a vehicle in the sense, or it can be the office equipments, furniture. So these things has to be under every partner itself. So so one partner cannot misuse these properties under the partnership business, in the sense, though they are not allowed to sell if within the consent of other partners, so they cannot misuse with the consent of other partners. Yeah, so the property bought in originally says that partner will transfer the property to all the partners, including himself. The partner transfers property trustee who would administer the property for the benefit of the partnership. The partners retains the title to the property and holds the property on trust. So Mile versus Clark. This is the case. Yeah, these are the things. So property acquired subsequently by partnership. So that means before I talked about before they starting a business, when people brought up properties, things that when they sign the agreement, these properties will become common in all the properties of all members. So second one, properties acquired by subsequent by partnership. So when you're running a business, in the middle of the business, when you buy things for the business, so those things. So the capital equity of the partnership, so the profits that you're making during the long run. So these are the cases if things has been violated. So relation between partners, normally these things governed by the partnership deed, the articles of the partnership of the agreement. So it refers to the agreement basic understand relationship between carrying on the business partnership businesses. So if there's no written partnership agreement, these relations are governed by the course of dealing among partners, which as a general rule is based on mutual trust, confidence of each partner, and the integrity of the other partners. Further, where no provision is found of partnership agreement will regulate between two parties. Smith versus Jayas. So if things are violated, it's a case. So rights of partners. Yep, it's very simple. All partners are entitled to an equal share. All partners must have entitled interest of the capital, and they should share the profits and the losses as well. They all entitled for remuneration, and yeah, all these things, and move on. So every partner is entitled to take part in management. So they all are managers, they all are directors when it's come to a partnership business. The consent of all partners is necessary to introduce a new partner. So if there's a new partner comes try to invest into their business, they must have consent of all the partners. Consent of a new partner. So there's a case. So yeah, let's read it. It's a case from England. So a partnership deed between Byron and Reed gave B the authority to introduce his son S as a partner upon S attaining at the age of 21. Subsequently, when S reached at the age of 21, he was proposed by B to be a partner of the firm, but R refused to consent to this proposal. Hence, R could not prevent S from being a partner as a particular clause. The partnership deed operated at R's consent. Yep, exactly. Because yeah, so R could not prevent S from being a partner as a particular clause in the partnership deed operated as R's consent. Exactly. So to decide by the majority decision all ordinary matters relating to the partnership. For removing a partners, you must have a unanimous decision of all partners. So partners is entitled indemnity, respect of payments, and the liabilities also they have to um, take it as a burden, I would say. So yep, and this keep going. Every party is entitled to inspect the partnership books and the records. Yeah, duties of a partner. So they should have a true accounts, full information of affecting other partners. Every partner should account to the firm for any benefit derived from it without the consent of other partners. So it's a case law Featherstone Hall versus Fenwick. This is case if things are violated. according to their duties. Says us not to compete with the firm. Partners not to compete with the firm. Pulin versus Mahindra. So partnership was conducted in the business importing of selling salt. One of the partners brought some salt for himself and sold on his personal account. Held, it is a fundamental rule in law of partnership that a partner cannot, without the consent of his co-partner, lawfully carry on his business competing with the partnership. As a partner engaged in such business competing, he is liable to account for its profit from the dealing by other paying it to the partnership. So exactly. So when you are having a partnership business, you cannot uh, you cannot bring your own things and sell it, make your own profits, because since you are branding your own partnership business, you all should work together in order to achieve the partnership business. So every partner must disclose any secret profit if he makes dealing with the firm and account which in order to show the profit to the firm. So these are the cases of things. So relation between partners and third parties. Yeah. So this the relationship between partners, third parties with whom partners deal with in relation to the partnership business will also be explained in this section. So relationship, which also referred to this relation, means the way in which two or more people are connected. So general rule. So it says that section 5 partnership says that what is so the purpose of the business firm, every partner is considered as an agent of the firm of this of the partners. So everyone is an agent when it's come to for partnership businesses. And so these, what are the exception rules, exceptions? So when a partner is so acting has an authority to act in the firm in the manner when a partner is not, he is dealing with either. So implied authority of a partner, selling goods belonging to the firm, purchasing on behalf of firm goods kind usually employed in the firm's business. So receiving payments of firm's debt, issuing receipts for them, engaging servants, employees for the firm's business. And says implied authority of a partner in trading firms. So accept, make and issue negotiable instruments in the firm's name, borrow money on the firm's credit and pledge the firm's goods to effect that purpose. Instruct a solicitor in an action against firm for trade debts. So this is the case. A non-partner holding as a partner. So what if there's a non-partner? What if is not in the circle and he's acting in the business? So it says, by his conduct represent himself, knowingly allow himself to be represented as a partner of the firm. So in such a situation, this person will be held liable as if he was a partner for the debts of the firm, but he will be held liable for those who debts incurred from the people who gave credit to the firm based on his representation. Further, just because a person holds out as a partner to a third party, he does become a partner of the firm at the end of the day. So yes, exactly. Even though if you work as a non-partner, you will eventually become a partner. The court will see that through their eyes of law. Yeah, so let's read these cases. Bevan versus National Bank. Says that Bevan is carried on a business in the name of MW and Co. To manage this business. MW was employed by the manager by B. The business owed money to the defendant, so which it was sued. MW is permitted his name to be used in the name of the business and also functioning as the manager of the business, had represented himself as a partner of the firm. So therefore, MW is also liable for this debt of the firm. So when it's come to changing partners, Section 9 of Partnership Act 1890 says that every partner is a firm liable in jointly with the other parties of the partners for the debt and obligation of the firm occurred while being in partnerships, while being in partners. So yes, so what are the things? So if there's a new partner, obviously should have consent from the other partners in order to become partner. So yeah, if X enters into a contract with Y to supply on credit, the entire stationery equipment for Y for 2 months. X has already supplied stock of stationery which Y has to pay. As Y does not have sufficient funds to settle X, he invites Z to join his firm as a partner. Z joins the firm and agrees to settle X for the stationery already supplied to the firm by X. For this purpose, XYZ enters into a new agreement which gives fresh terms for supply of stationery, as well as the parties consent to Z to settle X stationery already supplied to the firm. In this situation, second agreements replace and cancels the first agreement. This is called novation. Exactly. So existing partners, so retiring and resigning partners. So liability for debts incurred while being a partner. A partner who retires from the firm remains liable for partnership debts contracted while he was a partner. So it has liability for debts incurred after retiring as a partner. So the person with the firm before his retirement, he is liable unless he is given the notice as no longer partner. And for previous dealing with the firms, that if there's an issue with the firm that has been happened before, they can be retired or they can be removed. Yeah. So this is the case. Tower Capital versus Ingram. Death or bankruptcy of a partner. So death or by bankruptcy of a partner. So according to section 9, so the estate of a partner who is liable for the debts incurred by the partnership when the deceased partner was alive, was a partner of the firm. But the estate partner who dies or becomes bankrupt is not liable for the partnership debts contracted after the partner's death or bankruptcy, even if the partnership business is continued in the old firm's name, or even in the deceased partner's um, name is a part of the partnership name. So section 14 verse subsection 2 stated that in the act. So let's go about the case law, which is known as a liability of a deceased partner's estate for debts incurred by the partnership after his death. So Bagel versus Miller. Miller, a partner in partnership, died subsequently during M's lifetime. The firm ordered goods. These goods were delivered to the firm after M's death. The issue was whether M's estate was liable for the prices of these goods. Held that the debt, which is the prices of goods, was not incurred during the lifetime of M's, as the transaction was completed by the delivery of goods, which took place only after his death. So therefore, M's estate was not liable to pay these goods. So when a partner dies in a partnership firm, so they will be not liable for their debts included. But however, if there's some sort of so when a partnership dies, the estate will be not liable because it's already dead. The contract things has already been given from her. So whether the widow or the sons will pay off, it's all up to the partnership um, agreement through the business. So delictual liability of partners. So this section deals with the manner in which an action in court of law can be filed in relation to a partner. It also deals with the delictual liabilities imposed on the partners. How can a partnership suit or be sued? In order to sue, you must prove what sort of harm that is being caused by making legal claim for money or damages. Since the partnership doesn't have a separate legal entity for its partners, partnership cannot sue or be sued in the partnership's names. So therefore, any legal action by partnership or against the partnership will have to make the individual names of all the partnership of the business. So if you have an issue with the partner, since you are partner A and you have an issue with the partner B, so the partner B has done some liability fraud through the things. So it has to go through private name. So you cannot included your partnership, the business name that is occurred. The business name can be occurred when it's sued if you has done a business with another company. Exactly. So in this manner, wrongs committed by against it, yeah, such as I said before. So joint liability, severe liability, and joint and severe several liability. I'm sorry, it's several liability. So joint liability, which is that even though the liability is incurred by the two or more persons, they are each liable for up to the full amount of the relevant liability. Further, there will be only right of action against all the parties. So the example, so X and Y promise jointly to pay 10,000 rupees to Z. This means that both X and Y have undertaken together and to collectively pay 10,000 rupees to Z. Therefore, if either of them is unable to pay, the other will held liable to pay the entire 10,000 rupees. So several liability is where the parties are liable only for their respective portion of the total liability. Uh, so several liability, if X enters into a syndicate loan agreement for 15 million with the bank PN Bank. So the bank P agrees to give 10 million. Bank Q agrees to give 5 million to X. Under this contract, the syndicate loan agreement has a clause which says that each bank is severally liable for its portion of the law. If Bank P fails to give the agreed 10 million to Co-X, the Co-X can sue only Bank P. It cannot sue Bank Q and is not liable to the under the agreement for its 10 million. So yeah, so that's a several liability. So joint and several liability, which means that two or more people are jointly and severally liable to pay damages to a claimant. So in other words, um, in order to recover the claimant to recover all the damages for any defendant, so individual share of the liability has to be paid by the partnership. So uh, a classic example is that XY promise jointly severally to pay 10,000 to Z. This means that both X and Y has undertake to pay 10,000 rupees. So to Z and the individual capacity as well as the collectively, Z is then entitled to claim the entire 10,000 in any of the following ways from only X or Y or both collectively. So what are delicts? So if the delicts are tort, which are it's a tort, it's a civil wrong, which is inflicted in loss or harm into the affect. So normally these things in contract law, it's very common. And delictual liability of partners. So like if there's a liability in personal partners in the event of the firm has been committed or toward delictual liabilities. So the delictual liabilities of partners to third parties on the actions of the firm. So if the firm engages in the wrongful act or omission of a civil nature, all partners who were uh, partners who at the time of such an act or omission becomes delictual liable to the affected third party. This results in all such partners being jointly and severally liable towards a particular third party. So yeah, delictual liability to a third party of the action of a partner. So if action of another partner affects to all the partners in a partnership business, so every partner has to be careful, every partnership has to be careful of what sort of things that every individual partner does. So liabilities of a partner of the delicts committed by a partner. So if such wrong were done in ordinary course of partnership with the business, if such wrong has been done, the authority or consent to other partners. So These are the case laws. So within the ordinary course of business, and says that the liability of partnership for misapplication for third parties of property by a partner. So if the firm in the course is ordinary course receives money or property from a third party, and a partner misapplies such money or property while such money or property is in the custody of the firm. If a partner acting within his apparent authority receives money or property from a third party and misapplies such money or property. So dissolution of a partnership. So a partnership is not everlasting, it has a lifespan. In this section we will discuss how a partnership can come to its end. A partnership can be dissolved either by an order of the courts without any order of the courts. So liability of a misapplication of third parties to the partner. So if the partner is jointly liable to make good the loss of damages to a third party in any of the following instances: if the firm is causes during the course of business receives money or the property from a third party. So dissolution of a partnership has to be a court order without any order of the courts. So if we said dissolution by a court order, when a partner is incapable of managing firm's affair due to mental disorder, if a mental partner is permanently incapable of performing his duty, if a partner commits a breach, if a partner is prejudicial when carrying regarding the breach. So when a partnership carried at a loss, if the court thinks it's equitable to dissolve the partnership. So this dissolution without the court order, it becomes expiration of the notice by the partnership business that within this period of time, so the 5 years has been passed, either we have made the profit or it's a loss. So therefore partners has to agree that they have to end the partnership business or they have to keep going. So Vikramasuriya versus De Silva is a classic example of a case. Bankruptcy of death, subject to any agreement, partnership dissolved by the death or bankruptcy of the firm. However, the partnership agreement may give the rest of the partners option to either continue with the partnership or to dissolve it. So it depends on the business within itself that taken the decisions. So there are a few cases: McLeod versus Dowling, McLeod versus Dowling, which is the case, and the charge, the illegality, and so the treatment of assets on dissolution. So section 39 Partnership Act said that on the dissolution of a partnership is entitled. So this partnership always respect interest as partners. So there's be two ways: first, to pay debts and liabilities to third parties, and the balance has to between shared between partners, so in assets of a dissolution of a partnership. So yes, that's it of the law of contracts, and it's the end of the chapter 6, law of partnerships. And then I will see you in the next video, chapter 7. Thank you.